Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I want to talk about what is evidence. And in particular, I have a lot of criminal cases where the evidence is solely a complaining witness claiming that the accused did something. So, for instance, let's say there's a domestic violence charge, and I represent one of the significant others. The other significant other has claimed that my client has assaulted them, and that is the basis of the charge against my client. There's no video evidence, there's no independent witness, there's no corroborating pictures of injuries. It's just his word versus my client's word. And a lot of times my client will say to me, James, um, how can this case go forward? There's no evidence. I should win. It should be dropped. This is not fair. It's not due process. It's unconstitutional and everything. And I have to stop them for a moment and correct them. Somebody accusing another person of a crime, of a criminal activity, is indeed evidence. Testimony, if somebody's willing to get up and testify that you assaulted them, is evidence. Somebody swearing to a magistrate that you assaulted them, that is testimony that led to probable cause for a warrant issue against you. And if they indeed testify in court, that is evidence that a court will have to consider. Now, whether or not it's going to be enough evidence to convict you is a very different question. Under Virginia constitutional law and the United States Constitution, in order for you to be convicted of a crime, you have to be evidence has to be beyond a reasonable doubt of your guilt. The court, the government has to establish guilt beyond a reasonable doubt against you. So, in theory, if the accused is claiming that you hit them, for instance, and you're saying no, that didn't happen, and it's a he said, or she said, she said, and everything. If it's that situation, that everything being equal should not be guilt beyond a reasonable doubt. And if a judge or a jury is abiding by the Constitution, you should be acquitted. Now, that being said, it's not the end of the story. Just because someone is claiming that you did something and you're claiming you didn't, that doesn't automatically mean that you win. It's good facts if you did not make any incriminating statements, but there's issues of credibility that a judge or a jury may consider as well. So let's say their testimony came across as very credible and your testimony came across as very incredible. A court could convict you at that point. So I just want to be clear, just because a prosecution is based solely on statements against you by the accused, that's not the end all be all. And you can't simply rely on that and expect the case to be dismissed. I want to again emphasize that doesn't mean that I'm saying that you're going to be convicted, but my recommendation would be that you speak to an attorney who can give you their view on the evidence against you, help you understand a better idea about the chances of victory at trial versus losing versus maybe exploring a plea agreement, and get really specific advice on the specific facts of your case. So hopefully this information is useful for you. If you have other questions, feel free to reach out. You can give us a call. Phone number is 703-570-4180. You can also check out the website, www.abreniolaw.com. We've written a lot of articles. We've shot a lot of videos when it comes to Virginia criminal law, also personal injury as well. But if you're watching this video, you're likely uh, have questions about Virginia criminal law. So hopefully that's useful. You can also reach out to me, james@abreniolaw.com. So hopefully you find this useful. Feel free to reach out. Until then, stay safe. Thanks.